This video is about the top 5 steps to sell house in Chapter 13 bankruptcy. If you're looking for information on how to sell your house in Chapter 13 bankruptcy, then here are some quick tips from our realtors and attorneys that specialize in Chapter 13 bankruptcy challenges. For quick knowledge purposes, a Chapter 13 is a consumer bankruptcy for anyone who have enough money to repay a part of their personal debts. In Chapter 13, if you have a home, you're likely to be able to keep it, as your bankruptcy trustee will set up a repayment plan to your creditors, including your mortgage holder. If you decide to sell your home while in Chapter 13, you must inform your attorney early in the process and prepare for a lot of paperwork. Here are the top 5 steps in a basic order. Number 1, inform all parties involved. Whether you're in the middle of your Chapter 13 case or into your repayment plan, notify your attorney once you know that you intend to sell your home. There's a great deal of paperwork involved in selling a home while you're in Chapter 13, and your attorney needs time to inform your bankruptcy trustee and put the documentation together. In addition, you should inform your real estate agent and the prospective buyer that you are in Chapter 13. It's likely your attorney will craft language in the sales agreement that the sale is contingent upon the trustee's approval. Number 2, don't get started late. Time is of essence. Time is of essence if the process of the bankruptcy case is in the middle or if the trustee has not approved the plan. One should give an attorney anywhere from 30 to 45 days to negotiate the sale with your trustee. With that said, then an attorney will need time to put the paperwork in motion. In addition, creditors have a right to object to the sale, just as they have the right to object to the repayment plan. Number 3, motion to sell. The motion to sell is the major piece of the paperwork that's needed if trying to sell the home while in Chapter 13. I repeat that once again. The motion to sell is the major piece of the paperwork that's needed if trying to sell a home while in Chapter 13. The motion to sell documentation should include the sale price of the home's value, the home appraisal, or documentation to validate the home's value, and a proposal for distributing what differs of proceeds left over from the sale. In most cases, the proceeds are applied to paying off the mortgage and closing costs. This is a document trustees base approvals upon. If the trustee approves, the sale can go forward. Number 4, statement of sale. Once a home is closed, then a statement of sale will need to be provided to the attorney as proof, which is called a statement of sale. This document, like the motion to sell, is important to get to the trustee as soon as possible. The statement provides the home's final sales price, any closing related deductions, and how much is left over from the sale. Also, at this time, one is required to make any payments the trustee ordered during the motion to sell phase request. Number 5, discharge. If the home sale can pay off the repayment plan, then one can expect the discharge of Chapter 13 shortly after the sale. The trustee will order the discharge, which will be signed by a bankruptcy judge and then sent to one in the form of a final decree. This document is important to keep, as it proves one is out of bankruptcy. If the payment plan calls for one to make automated payments to the trustee, then payments will be deducted until the trustee can cancel the electronic transfer. Any money paid to the trustee after the discharge will be repaid to said discharge. So, what do you have to lose? Get the free 30-minute bankruptcy consultation from our attorney source and the free checklist bankruptcy document form. So go ahead and sign in.